y'all want.
Okay. Hello, everyone. So today's presentation is between the Spring Group and the Social Media Research Institute. And today we're going to be talking a little bit about Meta's ongoing lawsuits, specifically the large coalition lawsuit filed on behalf of 41 state attorney generals in regards to Meta's platform and the problems that it's had specifically for children and teenagers. So to start off, we wanted to go through a brief overview of our agenda, which will start off a little bit about the Meta lawsuit, and then we'll dive a little bit deeper into the problems with Meta's platforms, whether that's predatory design features, the inability to moderate content, alongside the effects of social media on youth, and then we'll finally transition more in towards the merits of the lawsuit and how we see the lawsuit may proceed. So first off, a brief background on the lawsuit. In October of 2023, 41 states attorneys generals filed a lawsuit against Meta. And specifically, the lawsuit alleges three main problems with Meta's platforms. Number one, that they implemented harmful and addictive features of its platforms, including Instagram and Facebook for children. Second, they downplayed the harms of its platforms on children, whether that's the problems of child exploitation on social media or addiction or mental health harms. And finally, it alleges that Meta violated provisions of the Child Online Privacy Protection Act, whether that's the issues of underage users on its platforms or issues with data collection and data violation of minors' privacies. So the first thing that we wanted to talk a little bit about is the harmful design features of the Meta lawsuit that are alleged in the Meta lawsuit, alongside the general issues of Meta's platforms, including Instagram and Facebook for children. So we're going to focus on four main harmful design features. And when we say design features, we're focusing on just specific problems or specific ways the platforms function. So those four design features are targeted algorithms, infinite scroll, push notifications, and targeted advertising. So first off, we're going to talk a little bit about targeted algorithms. So algorithms are obviously widespreadly used online and real life. And in social media, they're specifically used to ensure that content seen by youth keeps them engaged and on the platform. So before targeted algorithms were present on platforms such as Instagram, oftentimes those platforms were mainly focused we're mainly giving you content based on who you followed. But in the advent of advances in technology and in the quest to ever get more attention from its users, social media companies, including Meta, have implemented targeted algorithms. This manifests in various ways, whether that's on your own phone and Instagram, you can scroll through and see various content being recommended on your feed, or whether that's in infinite scroll, which we'll talk about a little bit later, where also additional content is added onto your feed and is recommended to you, instead of what typically is happening, where you just only show content in a chronological order from what you're following. And then the next part is also part of targeted algorithms, but it refers to infinite scroll, which are the endless scrolling features that are seen on Instagram's Explore page and Reels products. So infinite scroll isn't just used on Instagram or just on Meta's products. It's used on a variety of platforms, probably most well known, which is TikTok, where basically you can just keep scrolling on your phone and it's infinite in the sense that as long as you scroll, there's a new piece of content that's being shown up and you can never stop infinitely scrolling. So the benefit for this for social media is that infinite scroll gives the impression of infinite content, making it really hard to stop. Now, on one hand, this is great for social media because social media's economic models typically thrive upon making sure users spend as much time on the platform as possible, so that way there's more time for social media platforms to implement advertising or collect data. But on the other hand, it gives what one Google design ethicist described as a self-refilling bowl, in the sense that as you keep scrolling, you keep on getting more and more things coming up. And so, in other words, this self-refilling bowl is often described as partial reinforcement. So partial reinforcement can also be seen in casinos, where it's extremely addictive because in like classical psychology, when you go through something and you get a reward every time you do something, it's known as positive reinforcement. And that gets people conditioned to want to do things. But partial reinforcement is typically more addictive than other methods because you never know, for example, when you're scrolling, whether you're going to really enjoy a reel or enjoy a piece of content. And so sometimes you don't really enjoy that piece of content, but as you continue scrolling, you might find a piece of content that you like. So that's known as partial reinforcement, and it's typically more addictive than other forms of conditioning. And also in social media, it's also more addictive than things such as just having a simple chronological feed where what you're seeing is only just something that you enjoy or is only someone that you're following. The third form of harm in design features is push notifications. So push notifications are at the top of phone screens that are designed to prompt users to open the app. And so push notifications are on any platform and they're used by anyone. But something that we noticed and something that's well shown in the research is that Meta's push notifications are especially prevalent. So one research study found that Instagram and Facebook deliver the third and fourth highest amount of push notifications in a day. And so that means that because push notifications are really good at getting users to click on the app and open the app, the high amount of push notifications lead to a lot of kids, but also a lot of adults opening the app and either being distracted or interrupting their education or sleep. And so that's our second and third points, which is that 25% of push notifications, according to one study, are received during the school day, and 5% of push notifications are delivered at night. And so this is harmful for youth with 25% of notifications during the school day because it interrupts children's attention spans and takes them away from their education and makes them less engaged in their schoolwork. And in terms of notifications delivered at night, this can ultimately disrupt or harm youth's sleep and youth's like rest and recovery. And so that's actually something that we've seen that Meta implemented on Instagram as a result of public pushback, where Meta has ultimately implemented what's known as quiet mode from 11 to 7 a.m., which is offered on youth and also, I believe, adults, because it silences notifications and it encourages youth and adults to stay off online. The final issue that is regarded as a harmful design feature is targeted advertising. So targeted advertising refers to advertising that's on Meta and on Meta's products, whether that's Instagram or Facebook, that kind of exploits youth by giving certain goods advertised to them. And so this is both prevalent in adults and kids, but given that youth are much younger and their brains aren't as developed, this makes it very easily impressionable for youth to be encouraged by certain goods or push their parents to buy certain goods. Okay. The second thing that we're going to look at a little bit more on Meta's products is its failure to moderate content. So this involves four different things. First, the problem of child sexual abuse material. Second, the issue of COPPA and underage users. Third, the internal awareness that Meta knew that it was failing to moderate content. And fourth, its public misrepresentation issues. So the first problem that we're going to talk about is Meta's high prevalence of CSAM. So in a series of lawsuits, investigations, and news exposés, it's been well established that Meta has a big problem with C-SPAN, known as child sexual abuse material. So the first lawsuit is New Mexico versus Meta, which wasn't filed as part of the 41 states suing Meta, but came out at around the same time. And so this lawsuit included various allegations against Meta and various pieces of evidence that showed that on Meta's platforms, it was easy for users to simply search up child sexual abuse material online and be able to find C-SPAN. And furthermore, it also found that even when it was reported to Meta, I believe in the lawsuit, it noted that even though it was reported to Meta, it often wasn't actually moderated, which is a widespread problem that you see. And then the second problem we saw in Meta was that the algorithms were often alleged to have recommended illegal sexual content, according to a Wall Street Journal investigation. And finally, earlier investigation that came from the BBC alleged that Meta had invite-only groups for C-SPAN, which the BBC noted was often rarely moderated or rarely removed or reported to law enforcement. So overall, one of the big problems that has happened for Meta is that its products and platforms have become hubs for C-spam, which have become extremely problematic and often are not well regulated or moderated. And then the next issue involves COPPA, which is the Child Online Privacy Protection Act. COPPA is a US federal law that, in short, basically sets the digital age for consent, basically to use platforms to be 13 and older. And it sets rules where data collection has to be restricted for those under 13. And so as a result, most platforms, in order to avoid having to comply with these really restrictive policies, often require users to be 13 and older, especially because a lot of platforms engage in various forms of data collection that might have difficulty with falling in line with the COPPA law. A big problem, though, is that Meta's products have an underage user problem. So in various studies, it's shown that a lot of users have used Facebook or Instagram, which are Meta's two products. So 65% of 9 to 12-year-olds have used Facebook, 66% of 9 to 12-year-olds admit to using Instagram, and 11% of 11 to 12-year-olds use Instagram according to Meta's own data. So one thing that might lead to this discrepancy is that the questions in the first two, 65% and 66%, are a separate study from Meta's own data, and their definitions might be different. So it might be that the first study involves just children like having used maybe their parents' account, while the second one is just Meta, like younger people just using Meta and having like their own accounts. But either way, these both show that there's a high prevalence and problem of young people using Meta's platforms and products, even when it's technically not allowed by Meta's own terms of service. Furthermore, it's not just that Meta's own products are harmful for that children are illegally using Meta's products, but also that Meta's own internal research have shown that their products are extremely harmful. So 1 in 5 teens say that the social media platform, that social media worsens their self-image. This is just generally, but 30% of teen girls say that Instagram makes their body image issues worse, and 13.5% say that Instagram makes their body of teens in general say that Instagram makes their body image worse. So what's clearly well shown and well demonstrated through this data is that Meta is well aware that its own internal products are harming teens and their mental health, and it's also worsening their body image and their self-image. And in the long run, this leads to the wide range of problems that we have been seeing with teens' mental health, and alongside just general declines and harms that we've seen through Meta's own products. Jake, do you want to talk a little bit more about legal claims in this lawsuit and the grounds for those legal claims?
Yeah, so this section is going to be basically taking everything that Oliver already talked about and applying what I know about the law and past precedent and past cases to all of those facts that have already been brought out. So there's 3 grounds for which these states specifically say they have the right to sue on. The first is on the Unfair Deceptive Acts and Practices Act, which essentially says that companies that engage in such practices, for those companies, state attorneys general are permitted and also maybe even obligated to sue those companies if they are found to have been conducting those practices. So essentially, these laws prohibit these business practices from being used. The states are alleging that Meta did use them, like, for example, targeting towards children without overtly saying it. Secondly, the state attorneys general are suing them under COPPA violations because under the law, it specifically allows the state attorneys general to sue for violations. And again, as Oliver already discussed, there's basically 2 violations of the law: targeted advertising and a lack of parental consent. Finally, there's this doctrine called parens patriae, which essentially say that if a state has a quote-unquote quasi-sovereign interest, which is basically legal speak for the acting in the capacity of some sort of country or some sort of nation or government for their citizens, that means that they are able to sue. So for example, if they say, hey, all of Meta's activities are generally directly harming the well-being of all of our citizens as a whole, they can use that parens patriae doctrine and say that because of the harms to the public interest, they have the right to sue. So generally, when this lawsuit does go through, there's going to be a standard of preponderance of the evidence, which basically forces these states to prove more likely than not that these cases, or rather their case, is true. So it's an above 50% chance that their case is true. And that's the standard for all civil cases. This is also a civil case. So the states to satisfy this threshold have to prove basically all of the things that Oliver was alleging based on the different causes of action that they're claiming against Meta. So there's basically, right. So there's two things that they'll likely have to prove, and there's two separate standards that they can basically use that for. The first standard is knowingly. So there's going to be a lot of evidence that the states have to present to show that Meta knowingly acted in certain ways. So for example, all of the evidence that Oliver brought up about the reports, about people saying that these kinds of content existed, and about being exposés about this content on Meta's platforms, and Meta acknowledging the fact that those things exist and simply not doing anything about it. The second standard is recklessly. So essentially, as if saying that Meta, even if they weren't doing this purposefully or had knowledge of it, they acted so carelessly and with such little care for their users that they can also be held legally liable because of the amount of recklessness or carelessness that they practiced. Okay, you can go to the next slide, by the way. So these were essentially the four causes of action that the states specified against Meta. And for each of these causes of action, there's specific things they can prove, and there's also some specific shortcomings. Firstly, starting with addiction. So this lawsuit has basically have to prove that Meta's platforms were addicting to their users. So they can use things like Infinite Scroll, where the creator of that program literally said that if someone doesn't have the correct impulse control, they can just keep on scrolling and scrolling and scrolling and basically lose all control over their time because of the fact that they have badly regulated psychologies. The states also contend that when Meta created stories, which are basically posts that disappear after a day, they exploited the natural instinct or tendency of teenagers and young adults to have FOMO, which is basically fear of missing out, essentially saying that if I don't see this story, I'm going to see something my friend posted and not be able to see that. And it's going to go away after a day. So I have to click on it or else I'm going to miss something. And there's like some harms of social anxiety, social exclusion, all of those things that are very, very harmful to teens. However, the problem with this specific, actually, that's the next slide. I can talk about that in a bit. But the second thing is on child exploitation. So yeah, so this is the issue of certain children being targeted by explicit imagery. There being a lot of targeted advertising towards those children, and those children not being able to control themselves as well. So the issue here is that Meta has specifically received reports regarding a lot of inappropriate messages towards children. One of them actually came directly from an Apple executive who threatened to remove Meta from the App Store had that not been sorted out. And there's no information on whether or not it was actually sorted out, but that at least gives an indication that Meta was at least aware that these threats towards children existed on their platforms. And again, Meta receives a lot of these reports basically on the daily of a lot of inappropriate content, inappropriate groups that are all occurring throughout Meta. And most of the time, even though these reports are true, and this is stuff like from BBC, from other news sources that have specifically tested this by reporting a lot of these groups and finding out that most of them didn't actually get taken down, that essentially shows that Meta is being too liberal with the way that it is taking down its groups. So it's letting too many obviously harmful and obviously illegal groups slip through its filters, even when there are reports. The third issue is on self-image and social anxiety. And this kind of ties into addiction a little bit, but this is more of the implications of that. So specifically, things like filters on Meta platforms can create body dysmorphia, and that's what's directly being alleged by these states, that all of their teenage residents are experiencing a lot of these harms as a direct result of having filters and as a direct result of all of these users on their platforms essentially just posting the most perfect version of their lives, creating an impossible standard to live up to. So as a direct result of that, Meta actually took some action in decreasing the amount of eating disorder content or content promoting such eating disorders, like, for example, anorexia, to young teenagers. And although they did take that step, and that might have been a step in the right direction, the lawsuit can use that to allege that they didn't take proper action until pressure was actually put on them. So there are still valid causes of action for that lawsuit to go through. Finally, it's on COPPA. And again, there's essentially two parts to how Meta violated this. The first was that Meta knowingly collected personal data from children. So obviously, whenever you go onto a website, now there's targeted advertising that takes the preferences that these advertisers know you have and targets you with specific advertisements that they think you're likely to enjoy. So the way they actually have that targeting is by knowingly collecting data on you over and over again. So the states are essentially alleging that since Meta has underage users, they were knowingly collecting that sort of data for targeted advertising on those users. And secondly, it was about direct advertising to children. So for example, the presence of a lot of family targeted creators on Meta's platforms like Instagram, and the fact that these platforms can actually be used as ways to disseminate that sort of content and advertise directly to children is another lawsuit, is another harm for COPPA that can be the ground of a lawsuit. But this does obviously come with shortcomings, and that's going to be on the next slide. So let's just go back through each of those four things and talk about where they actually might fall short. Firstly, on addiction. So the harm that Oliver mentioned, PIMU, or problematic interactive media use, is generally recognized to a certain extent, but it is mostly very newly recognized, and it's still not very widely recognized, specifically not necessarily recognized enough to be, for example, the basis of an expert's testimony in a court. So what happens in court a lot of the time is on cases, especially ones like this, they will tender certain people as experts in certain fields to provide opinions to the jury, because no other types of witnesses are directly allowed to provide opinions. The other witnesses will only provide facts. But if you're certified as an expert in a certain field, you can provide opinions and use the facts that other witnesses have brought out to convince the jury of a certain position. But what's the issue there is that it requires certain qualifications to be an expert, and you have to be qualified as an expert in a certain field. So the issue with PIMU being so new is that it is still uncertain as to whether or not it will be recognized, and that someone who testifies about it in court will be certified as an expert. The second thing is child exploitation. So the problem here is that Meta specifically alleges back against the states that it has taken measures to protect against a lot of these harmful child exploitation contents. So although this might disprove the allegation that Meta fails to take action, it's again still an issue for a lot of that evidence that's been shown that it directly ignores reports or acts wrongly on them that can still be used as the basis for an action against Meta. But it has shown that it's taken some sorts of action, and it provides a lot of specific examples of tools that parents have and that it provides those parents to regulate this sort of content. However, obviously a lot of stuff still spills through the filters that Meta provides, and a lot of those tools aren't necessarily effective 100% of the time. That's still the reason why this lawsuit is still happening. The third thing is on self-image. Meta specifically says here that it's actually the opposite effect, that its services have the capacity to make teens actually feel better about themselves. They also directly attack the evidence that the states provide, because they say that a lot of these studies they provide actually conflict with each other. Finally, on COPPA, what they say here is that there's a lot of measures that Meta has already provided to make sure users properly verify their age before they, for example, collect data on them. So obviously there's a lot of things like when you create an Instagram or Facebook account, there's a minimum age requirement. If you put your birthday as a certain date and you're not old enough, you'll be barred from creating an account. The problem with those requirements, though, and the reason why this lawsuit is still going through, is that if you just put in the wrong birthday or you lie about your birthday, you can simply just get in on an account so easily. So they haven't, for example, introduced a method of identification, like, for example, having to provide a government ID to actually access those sorts of websites. So in a lot of areas where they've banned social media for individuals under certain ages, they've used that sort of ID verification. However, Meta has not, and that's why a lot of people still slip through the cracks. All right, next slide, please. Okay, these are the precedents of past cases. So what happens a lot in the legal world is that judges define their decisions based on things that have been ruled in the past. So I guess the most basic example of this is if you look at like the Brown versus Board decision back in the 1960s, that's become precedent because after that decision, everything that was upholding segregation slowly got knocked down because judges were making decisions in line with that. Obviously, this is an entirely different issue, but it follows the same principle that past decisions on laws like COPPA will carry forward to the future because judges are obligated to follow higher court rulings on certain issues. So there's been some cases regarding COPPA. Firstly, between Google and YouTube. So what essentially happened is that on YouTube, there was a lot of YouTube channels that are specifically making children's content. And what YouTube had to do as a direct result of this COPPA lawsuit was restrict the extent to which a lot of those channels could function or advertise directly to children. Because there was a concern about parents not being able to control the watching preferences of their children if they were being directly advertised to through specific users on YouTube. So a lot of child-targeted YouTubers on the platform, even if they weren't necessarily implicated in anything bad, were restricted in their abilities to, for example, have ad revenue on their content to discourage them from directly advertising to children. Secondly, on Microsoft. Microsoft was sued for the Xbox Live gaming service and its failure to provide adequate notice before it started collecting personal information. So something similar could be used for Facebook, where again, a lot of these teenagers simply slip through their filters and slip through the birthday verification and are able to collect that. And that means that Meta is able to collect their data without knowing that they might actually be underage. So that's the reason why these past cases can essentially be used to justify the holding in a new case. All right, next one. Okay, now we're going to get into what Meta has essentially said. So when you have basically any civil lawsuit, after the plaintiff, which in this case is the 41 states, files their lawsuit against the defendant, it's customary for the defendant to file back what's called a motion to dismiss. And a motion to dismiss is essentially an allegation that there's not been adequate grounds for a lawsuit stated in the plaintiff's complaint. So this very rarely succeeds, but it's a customary measure in just the 1% chance that it succeeds, and the defendant can essentially take out the lawsuit before it even gets started. So this was basically the content of Meta's motion to dismiss and its direct responses to the allegations. Firstly, there's a law called the Communications Decency Act. And this is something that's been in the news a lot recently because of the failure of a lot of social media platforms to regulate disinformation and extremism on their networks. So what it essentially says in Section 230 is that social media platforms can't be sued for certain content that their users post to their platform because it is not their speech or their content. It is basically the content of their users, and they are used as a proxy to use as a platform for that sort of content. So what Meta essentially says here is that they're unable to be sued because it is not their content. However, the court ruled against this because, again, obviously, most motions to dismiss are not granted by courts, and it was very similar here. They essentially said that the business practices of what encourage this content can still be used as grounds for a lawsuit. Secondly, they talked about the First Amendment, and this is kind of similar, where it essentially says that companies can message or advertise however they want because the First Amendment protects them. And again, they don't necessarily have to choose to take down certain content because of the First Amendment. Again, the courts ruled that the First Amendment doesn't protect the fact that they fail to inform parents and families about things like data collection, or they fail to act on known reports of illegal content on their platform. The third thing they say was that Meta is not a product subject to the product liability lawsuit, like, for example, the Unfair Deceptive Practices Act that we talked about earlier, because it is instead a platform through which maybe different products can be advertised. Again, the courts disagreed and said that it should be subject to product liability because of the fact that they're running a company, they're running a business, and they're running multiple different social media brands that could all be construed as products. Fourthly, Meta says that it doesn't owe a duty to parents and children to protect them from third-party content. And again, this kind of ties back to the Communications Decency Act, where they say, hey, it's not our content that's the problem, it's what people post to our platform that's the issue. And the court actually did agree with Meta a little bit on this. And they said that they don't owe the 41 states a duty to protect them from this third-party content. But they did say that there is a duty to reasonably design systems that go against the risk of this content being promoted on their platforms. So although they don't have the obligation to take down every single piece of child like pornographic or sexual material that goes on their platform, they should at least have the capability to take reasonable action to regulate as much of that type of content as possible, which the states are alleging, like rightfully and correctly, that they didn't. And finally, Meta said that the plaintiffs didn't show proper legal causation because it was essentially like a correlation thing. There wasn't enough direct evidence. Again, the courts recognized the existence of academic studies and the fact that there's a lot of direct data backing up the plaintiff's complaint. So essentially, what happened was very normal in the legal world, where this sort of motion to dismiss gets filed, and then they say that it's not a correct motion to dismiss. Because what a motion to dismiss actually has to allege is that there's no facts that can successfully support the cause of action of the plaintiffs. Not necessarily that the facts are wrong or disputing the facts, but saying that there's no facts or no basis at all. And because it's a very, very low bar, the motion to dismiss was denied, and this will likely proceed to trial. And that's basically the end. If there are any questions, we'll be happy to answer them.
Okay, let's open the floor to any questions anyone may have.
Okay, well, I'll start with a question. So when it comes to your thoughts on that, well, I mean, it's now almost a year later, But when you see what's currently happening in the legal field today when it comes to Meta and all the things that are going on in current day, do you think that it would be successful for them to be held liable at any point in time? As you can see, Zuckerberg is coming out with statements of saying that, you know, a lot of the ideology that I guess is being developed is on us, not them. And their original goal was just to connect the individual, not control what they say and do online. Is that something that you think in court, or in this case, a review of this type, could it be used to justify the need for more support, or could they even be held liable to support development of said products that are made more upfront than behind? Because a lot of the things that I guess you can say we currently see as users, they say exist, but if they didn't tell us or we weren't made aware, we wouldn't know they existed. So is that something that the courts could make them do, or is that something that you think, if it's brought to light, could be more in your upfront or in your face, if I'm making any sense?
Yeah, so if the plaintiffs win a civil lawsuit, there's generally two remedies that can happen. One, they could get a money settlement. So I think for a case like this, if the plaintiffs win, it's going to be billions and billions of dollars. But the second thing that the courts can order is what's called an injunction, which basically forces the defendant to take a certain action. So if it's a lawsuit for, I guess, property damage, for example, the courts can order a defendant to repair the property of the plaintiff because they damaged it. So in this case, if the states do successfully win, then yes, as you said, the courts would be able, for example, to order Meta to continue doubling down on a lot of those things they've been saying, in which they're going to directly protect more children with a lot more measures intended to give parents more control over social media. And they can use the force of the courts and a legal obligation to put that on there.
Okay. And another thing, I got another question. So when it comes to this, because as you know, they correlate it to the cigarette industry back in the 90s, when they basically said that, you know, the cigarette company knew what was going on, but they ended up making more money after the fact once they were held liable and they were responsible for creating campaigns. So is this something you think that big tech could possibly benefit from if they were forced to support, to me, third party development of education or anything of that nature for the parents or kids that they're affecting, if they even accept the fact that they're affecting? Because I mean, they know it's happening, but if they accept it, then that means they're going to be held liable.
Oliver, you want to talk about this or?
Yeah, so in my opinion, I think one thing that means, like, regardless of whether or not Meta wins this lawsuit, there's still ways for the platform to make a lot of money, whether that's through advertising or through any other forms of like making money or like memberships for its own internal products. But I think in terms of actually reducing harm, while if this lawsuit ends up in the state's favor, this could send a huge message in favor of or calling out tech companies and holding them accountable for their actions. But in the long term, in order to create more sustainable products or a better social media ecosystem, it might require policymakers to get engaged. So whether that's what we see in the United States with the Kids Online Safety Act that was unfortunately shot down, a lot of the a lot of the actions for making social media safer online might either have to be actions that tech companies ultimately pledge to take, or ultimately the result of governments filing new regulations, whether that's restricting the ways kids can engage online or restricting the way that platforms design their platforms. So like eliminating addictive features to better protect kids online, and also holding a standard and requiring platforms to better moderate their content from child sexual abuse material or unwanted messages by children.
Thank you.
How do you see Meta reacting to this during discovery? I know they're going to drag their feet as much as they can on their internal studies, but do you think ultimately Meta is going to comply with the discovery phase of this, or will they just do what they've done in the past, be held in contempt and pay the fines?
Yeah, so I think in my experience, at least, there's only so much you could do to resist discovery, since there's a lot of ways for your opponents in court to compel you to turn over certain documents. So even if there maybe is a time delay, I think the force of 41 states added to the legal obligations that the courts can put on Meta to turn over certain evidence And on top of that fact, the independent investigations that a lot of journalist outlets are already conducting, yes, maybe Meta can resist. And I think if you're saying in the past they have, I think they will continue to resist in this fact, especially seeing how I guess strongly they responded in their motion to dismiss about the sort of like lack of evidence that they're alleging. I think they may continue to resist as well. But the worst thing that could do is just simply put a time delay on this lawsuit. I think inevitably they will get the necessary information from Meta and the necessary evidence to make the lawsuit proceed.
How do you see Meta's recent decision to switch to user notes from moderation in the United States affecting this lawsuit? Do you think it'd have any kind of force at all in the final decision?
Oliver, you want to answer or can I do it?
Yeah, you can go ahead.
Okay, so I think the maximum extent to which the decision to switch to user notes would affect the lawsuit is if there was essentially a misinformation angle. Because I think the criticism with user notes is the fact that a lot of the time, the inherent bias of the people who are on that platform can seep into the supposed objective review of certain content that they're conducting. So I suppose on Facebook, if essentially you only have people from one side of the political spectrum acting on such user notes, you won't be able to actually have a both-sided picture of it. So if there's another angle that might be introduced in this lawsuit, it could be extremism. It could be the fact that political polarization might get worse as a result of their lack of regulation and their newfound decision to switch to community notes. I personally thought it was a very interesting decision myself because of the fact that it's been under a little bit of fire from Twitter. Like when Twitter first did that, essentially, it's like not necessarily a perfect system from experience. As a direct result of that, I think the possibility of a polarization angle to this lawsuit, I wouldn't totally rule it out.
Okay, I got a question. So when it comes to the discovery part, because Zuckerberg went on the Joe Rogan show yesterday and literally basically expounded on the reason why he changed from community notes to where the fact checkers, he broke down the reason for the switch, and he basically was saying that with the advent of Elon's push for community notes and how he saw it was more publicly checked and balanced than internal through third-party fact checkers. Could that be used to kind of validate, or his words on Joe Rogan, could that be used to validate admission of guilt to some degree, that he knew as the founder, as a CEO, that his product or his company was basically admitting to the fact that there was a problem, and them changing over to the fact that they knew that they were changing policies around based on another company who is known for that type of stuff? Is that possible?
I think the issue with introducing that kind of statement in court is because it inevitably run into some problems with hearsay. So usually the statement of the defendant is exempted from hearsay and you can get it in. But because the defendant is Meta Technologies, you'd probably have to prove that Zuckerberg was saying that in the capacity of his role as leader of that company rather than just his personal opinion, for example. So I think that's the issue with trying to introduce it. But what they definitely could do is if they were to call Zuckerberg as a witness, and he would be subject to cross-examination. If he were to change his story, which would definitely be a bad move, especially optically, then they would definitely hound him on it. The fact that he said a different thing out of court, and at that point they could probably introduce the out-of-court statement because it wouldn't be used. This is kind of like a legal thing, but it wouldn't be used to prove a specific fact or a truth of the matter, but rather just to show that he's being inconsistent. So you can't use something that was said out of court as fact. So you can't use it to say Zuckerberg saying this means he truly is doing this, but you can say because he said a different thing out of court and it's inconsistent with what he said in court, you can use that to essentially impeach his credibility and make it so that he's not as trusted on the stand. And if you ask him that question and he does agree with what he said out of court, then yes, you could definitely construe that as an admission of guilt because he specifically made that statement under oath and in court.
Thank you.
Yep.
Other questions? Well, thank you, Spring Group, for presenting your research. It was very enlightening. again, this is being recorded so that we can share your insight and your ideas with others through LinkedIn primarily. But just want to thank you for your time and your effort in putting this together. Thank you very much.
Yeah, thank you for the opportunity.
Thank you. And do y'all have anything y'all want to say to cap it off?
I guess just like ending it off, this kind of shows that members of the youth, even though we don't have the ability to vote, we don't have the ability to run in elections, the best way to get your voice out there is to do research like this, is to basically ignore the fact that there's all of these restrictions on your voice and the power that you have, and just make your opinions heard, because that's really the only way to get around all of these restrictions and make it so you actually have input over the policy process that affects you.
I wanted to, before we finish out, just thank all the members of the Spring Group. So me and Jake both worked on this paper, but there were a variety of different authors, contributors, and fellows who worked on the project. And I want to thank all of them, the Spring team, for making that possible, especially Brian, who's the chair of the Spring Group and who leads all of these operations, and Arik, who's our editor and also a fellow who plays a significant role in helping bring these products to life and ultimately turn these research products from just our own thoughts, ideas, and sources into like an actual finished product that's able to be published or able to be shared with the entire world.
Yep.
Thank you very much. And from the Social Media Research Institute, we are grateful for your insights as the youth, bringing that youthful side to what we do. And people definitely have read your work and they like your insights and just how y'all are bringing that fresh take, new generation take as well. So again, thank y'all. And thank you for joining us for the 2025 the Spring Group and Social Media Research Institute, a legal analysis on the Meta ongoing lawsuit. Thank you.